Good evening, everybody. I hope all those who are watching live are having a nice evening. If you're watching this on replay, whenever and wherever you're watching it from, I hope you are doing well as well. My name is Jonathan Ginsberg. I'm a Social Security disability attorney. I do represent claimants, clients all over the country. I'm able to do that because disability hearings are done by telephone or video. So it doesn't really matter where you're at, doesn't matter where I'm at. In fact, I've got a hearing tomorrow. My client's in Washington State, the judge is in Kansas City, Missouri. I'm in Atlanta, Georgia, and that's just the reality of Social Security disability practice now. No matter who you choose as your attorney, it doesn't really matter where they live because it's all pretty much done virtually now. You can still request in-person hearings, but it's pretty rare. You don't see it all that often. So anyway, I wanted to get that out of the way. Also, let you know if you had not heard, Social Security does now have a new commissioner, Frank. I think it's I'm not sure I pronounce this, Bisignano. He is a former financial guy. He was nominated. The Senate confirmed him. Bisignano, I think. And anyway, he, released a message saying that he's ready to get to work, that he values the integrity of the Social Security system, and hopefully he will be true to his word. I know there'll be a lot of pressure on him to reduce the amount of benefits going out, but again, you never know what's going to happen. Certainly having a commissioner who has dealt with big organizations before will be a good thing, and hopefully he will prove to be somebody who is compassionate, who understands the needs of Social Security and the needs of people who are requesting it, that it's a really difficult decision to make to decide to pursue Social Security, and that you should get a fair hearing when you do. So hopefully that will be the case. All right, so let's jump into the questions. Kevin Johnson says, what does it mean if my claim is pending additional development? I've been in recon since April of 2024. Well, first of all, let's see here. And Kevin says probably has had one or two adjudicators, maybe one quit. It's hard to get through now. It'd be 59, be 60 in January. All right, so I think first of all, if it's been in recon since April of 24, now we're at a year. In my opinion, that is way too long. It shouldn't be anything beyond about 5 or 6 months. I think you should contact your U.S. Senator, ask for a congressional inquiry, saying this is causing terrible hardship. You file for reconsideration in April of 2024. It's been pending, still pending, over a year later. Additional development basically is just kind of a catch-all phrase. It means that they are still planning on requesting additional medical information. They want more information. It doesn't really mean anything. They may already have everything they need, but it's easy just to say we're, pending development of the file. What actually is happening is when you file an initial application, the case goes to Social Security. They assign it to a state agency in the state where you live. The state agency are employees of your state, but it's funded by Social Security. These are what they call adjudicators or claims managers. The adjudicators will request medical information, sometimes non-medical information. They'll send you out for consultatives. They will, send forms to you, asking you to fill out forms, things like that. As that information comes back in, they will put it together in a package. They'll give it to a medical specialist, somebody in the Social Security system that is qualified as a medical specialist. That person will look at it and offer an opinion about whether you meet a listing or whether you have a disabling condition or conditions. The adjudicator, based on that and his or her own knowledge, will issue a decision. If you lose that initial, then you have 60 days to file a reconsideration, which is an appeal requesting that the state agency reconsider its decision. It goes back to the same state agency, but it's to a different adjudicator. Most of us in this business considered recon to be a waste of time. Statistically, about 35% of applications are approved. When you get to recon of the people who appeal, about 15, 16, 17% of those appeals are approved. My experience has been that most adjudicators at initial recon are looking for listing level cases where there's a really significant, clearly disabling condition. They are not generally going to make a decision about if you have, let's say, multiple medical conditions. they're not going to make a decision that the combined effect of those is disabling. Usually that's going to be something they're going to leave for a judge. So to say this, it's a recon waiting for additional medical development, kind of a cop out. They should already, at the initial level, they should have gotten most of the information. Recon, the first couple of months, they should have gotten more. This case should have been decided, right or wrong, approve or disapprove. It should have been decided. So what I would do is I would contact your senator and I would ask again for a congressional inquiry and get this thing moving. I had an issue. I'll just tell you, I had an issue with Social Security. They claim I was paid improperly on a case. They kept sending me nasty letters, threatening me, and finally, I'm like, I couldn't get through to anybody, so I contacted a U.S. senator in Georgia, where I live, and said, "Look, they're threatening me. They're making all these. I haven't seen any evidence at all. Can you look into it?" And within like 4 or 5 days, I'm getting calls from people, and it's going to get resolved. So, I think going to your senator makes a big difference. A lot of my clients do that. And I'm looking at the files that says expedited, which means it's been speeded up because they went to their senator. So I would definitely tell you to do that. A year for recon, way, way too long. And then Kevin has also been nice enough to tell me that he has nicknames for me and for Stephanie Joy. Stephanie is a friend of mine, another attorney. She is in Pennsylvania. And I'm Grandpa Panda, which, okay, being a grandpa is the best thing ever. And Stephanie is Goldilocks. She's blonde. So she does, I think, a live stream. I think it's on Wednesdays at noon, maybe a lunch hour type of thing. Very, very good attorney. We've become friends. We never met in person like everything else nowadays, or it's all virtual. But she, I think, really cares for her clients, does a good job. And she's been on this live stream several times to answer questions. And, certainly if you have the time and so inclined, find her on YouTube. And I think she's on Rumble as well. And, tune into her live streams. I think you find, sure she gives good information. I haven't done it yet because I'm usually pretty busy at noon, but I will try to do so. But thanks, Kevin, for the nicknames. I've been called a lot worse, so I'll take it. Shub says on May 6, 25, which is yesterday, a representative of the Kansas City started a final review to make sure you meet the 9 medical requirements for disability benefits. Feel like Carly Simon, right? You're still anticipation, right? You're still waiting. And they pay back pay from the time when you stop working. So what they're doing, the non-medical requirements basically would be they want to see in a disability case, they want to confirm that you are not working, because realize Social Security does something called a 5-step sequential evaluation process when they decide if you're disabled, and the definition of disability has to do with your capacity for work. So the first question they're going to ask is, are you working? So when somebody is about to be approved, and that sounds like where you're at, Shub, is they will confirm that you're not working. So they check with the IRS. They look to see if any earnings are being reported in your name. If so, they will ask questions about those. I've seen situations where people are getting severance pay. They are getting separation pay. They're getting accrued vacation or sick time. It could be any number of things, but it's not work. And so as long as you're not getting paid for actually working, it shouldn't be a problem. But they've got to go through that process to make sure they're not approving people who are back in the workforce. And of course, if they think you are, they're going to ask questions about it. But that process shouldn't take very long, a week or two. But, again, in the current climate, it could take longer. So you have to be patient. And as far as back pay, it's basically you allege an onset date when you file. That's the day you say you became disabled. Usually it's when you stop working. It could theoretically be a week or two before you stop working if you sort of were on, family medical leave or you weren't going in very much. You could argue that, you became disabled before you were officially terminated. Or I've seen some cases where people remain as part of the workforce. They're technically still employed, but they're not going in. Maybe the employer wants to let them stay on the medical insurance, something like that. But it's really when you stop performing work at what they call substantial gainful activity, or SGA level, which again is doing a job that is essentially equivalent to something competitive in the national economy. That's when your onset date would be. The date of filing really has nothing to do with your onset date, although in an SSI case, the earliest date you can claim for SSI is the date of filing. So even if you became disabled 2 years before, And an SSI, not SSDI, but an SSI, the earliest date you get paid is the date that you actually filed. I will also tell you that Social Security has been a little more aggressive lately in changing the onset date. So if you're at the administrative level, in fact, my hearing tomorrow is a case where they approved my client, but they cut out 3 years of past due benefits, which we figured out to be was going to be $50,000 or $60,000. So I appealed an approval. Essentially, I told my client, I think that we don't have a lot of risk here because clearly you're disabled. I think, and the worst comes to worst is they'll go ahead and just affirm what the state agency did, or if it's going to be a new review, of course, it's at a hearing, it's going to be a brand new review, but I don't think they're going to find him not disabled. So I said, to me, it's worth rolling the dice that they find you approved as your original onset date, and that'll put another $30,000-$40,000 in your pocket. So we decided to do that. So I'll let everybody know what happened. But tomorrow my hearing on this case, and my client I think is deserving of that money. I mean, again, I think Social Security is trying to save money, so it's easy to for them to say, well, we'll approve you, but as of 2 months ago, so they don't have to pay past due benefits. But that's not fair. And so I think that if you have evidence to show that you can go back before then, you can fight that. But again, it puts people in a very awkward situation. Now, if they do approve you, they will pay you, so you'll get paid ongoing benefits. The problem is if you lose, if you go to the hearing and realize when you go to a hearing, it is what they call de novo review. It's a brand new look at the whole thing. If the judge, you draw a bad judge, and the next thing you know, the judge says you're not disabled at all, you've been collecting benefits for 2 years, they're going to say you need to pay us back. Now, you can bankrupt on that, but that would be a really, really difficult situation. But if you decide to appeal a favorable decision from the state agency, that's what could happen. Our case, we have a judge with a 61% approval rate, so I'm pretty comfortable that he's not going to deny my client outright. And again, the worst case would be he'll find him disabled, in this case at age 60, as opposed to age 57, which is when his onset was. So again, I think we have a pretty good shot there, but that's what happened. So Shub filed on January 31 of 25. He is 56. So again, as of your 55th birthday, you could look at the grid rules, and the grid rules might very well be the thing that pushes you over the finish line. So, but it's not the date of application, it's the date of your onset that you claimed. And he's got osteoarthritis in both knees, which again says to me, look at the grid rules, and you're 56, and look at your 55th birthday, was your onset, on or around then, after that. As of 55, if you can't do light work is defined as standing and walking 6 out of 8 hours in a day, lifting 10 pounds frequently, 20 pounds on occasion, and you don't have transferable skills, then you would meet the grid rules. So you've got a really pretty good argument there at 55 that you meet the grid rule for light work. And again, if you've got significant pain or medication side effects, any skills you might have acquired would be eroded. So in other words, the argument is any skills you may have had would be non-transferable because of the effect of chronic pain, poor sleep, medication side effects. And then if logically you've got bad knees, you can't stand, and you've got evidence to show you can't stand for more than, you can stand for less than 2 hours total in a day, pretty good argument there. And again, you would have to testify. You want to make sure you testify that, your standing is limited to maybe 10 or 15 minutes at a time, maybe an hour or 45 minutes total during the course of a day. And by, you are making what they call prima facie case that you meet the grid rule. So that's the argument you would make. Then you could also make a functional capacity argument where you say the combined effect of my knees, the medication side effects, if there's situational depression, anything else, the combined effect of all that would be to make me unreliable such that I would miss too much time from work. That is a second theory of disability, and I would make that as well. So, I think that you've got a pretty good argument there, and that's how I would look at it, certainly. Let's see. Okay, who at the end will be the Witcher? Well, I'm not sure what that means. If it's 40 or 50 odds, now I can't believe it's 60 boomers be screwed. Not sure, Kevin, what you're getting into, what we're talking about there, but bad knee, Certainly, a bad knee again is going to be a situation where you could beat the grid rule if you're over 50 or over 55, because standing and walking with one bad knee is going to be just as difficult as with two bad knees, especially if there's evidence that you need a knee replacement or you need surgery, you had surgery. Um, let's see here. Okay. Blue Z. Is this correct? My attorney took 25% of my back pay. Now that my children were approved auxiliary benefit, back pay is also taking 25%. Is that how it works? My understanding is that the attorney gets 25% total, not 25% of yours and your children, your auxiliaries. Now, the total amount the attorney can be paid under the current rules is $9,200. So if the back pay on yours was, let's say, $6,000, and let's say the back pay on yours was, let's just pick a number, $24,000. And so 25% of that would be $6,000. So the attorney would get 6,000. Then if there's auxiliaries, the attorney would get 25% of that up to $9,200. So there shouldn't be a total of more than $9,200 paid to the attorney. But if your past due is less than $9,200, then the auxiliary part would be in addition to that. So you don't get more than $9,200, but you get up to that with the entire family that you're representing. So that's how that works, if that makes any sense. Okay. Mark is back. I know Mark and I communicated a little bit during the past week or so. The flu, I know you knocked you out. You told me that. And Mark asked me to talk about the appeals process. I found a favorable decision from the ALJ, which I know we are dealing with in his case. And by the way, Mark, I think I left you an email that we are going to pursue an appeal. And basically, I'll just tell you what I do is when I get an unfavorable decision, I like to have another pair of eyes look at it, because I look at it and, I may see, and Mark and I talked about this in this particular case, that there was some issues in the judge's decision where certain disabling elements of his case or a person's case was not properly examined, was not discussed, not included in the hypothetical. So I have another attorney. In fact, the attorney I have look at it is a gentleman named Carl Osterhout. Carl's partner and wife, Lindsay, who's a friend of mine, is going to be on with me next week, and she'll talk a little bit about this as well as what happened at the NASCAR convention and kind of what she's hearing as far as updates and so forth. But anyway, I'll have Carl look at it. There's another attorney named Brian Konoski. Sometimes I have him look at it. And, if they feel like there is enough there to support a federal court argument, then what they will suggest is let's go ahead and get an appeal filed. We will file kind of a very summary appeal. I'll file that. It doesn't really go into a lot of detail, but it's enough to trigger or to set out the issues. The appeals council generally is not a very friendly place to claimants, so the decision from the judge will be affirmed more likely than not. Then it goes to federal district court, and that's where Carl would do his magic. And so he would file a federal district court complaint, discuss kind of the legal issues there, and that's pretty much what he does. There are several attorneys out there. Carl's one, Brian Konoski is another, Adriana De La Torre, who's going to be on in a couple weeks. She was a couple weeks ago. She's going to be on again soon. That's what they do. They do federal district court work. And so I co-counsel with them. They draft the appeal. We file it. If we're successful, the case will be remanded back to the judge with instructions for another hearing and instructions for the judge to do a better job in asking and evaluating the evidence. Many times judges kind of get the wink, wink, nod, nod. We're taking the time to remand it, approve this case. And so that's a lot of times what happens. Not always, but a lot of times that's what happens. So that's the way I do it. Now, there are some attorneys who do both hearing work and appellate work, where they have an attorney in their office who does appellate work. I know my friend Chad Johnson is an attorney in, I think, North Carolina. I'm going to be on Chad's podcast in a few weeks. But anyway, he does it. He's got an attorney in his office who does appeals. I just do hearing work in my office. So I've just found that I don't like to dabble in things that I'm not, really up on. And I think appeals work is a sort of a different animal because you're dealing with federal district court decisions and especially in multiple states. And so I just, bring on somebody who does that. It remains contingency. It remains no fee unless you win. And myself and the person I bring in, we would split the fee. The only difference in the contingency is there's no $9,200 cap. It's a straight 25% because, again, you're going to federal court. So, Mark, to answer your question, that's kind of the next step. So, in your case, or a lot of other cases that that if I get an unfavorable decision or somebody reaches out, they've got an unfavorable decision. If one of my co-counsel that I really rely on says, yes, I could win a federal court case here, I'll file the appeals counsel brief, sometimes successfully, sometimes we get a remand. If that doesn't work, it goes to the appeals level. So that's the way I do it. Again, some attorneys do everything in-house, some bring on other people. But I think you need to have somebody who does the appeals work, who is very knowledgeable about the case law, the federal district court work, the process, the procedure there. It's just a different ballgame than the hearing type of stuff. And like I said, I don't like to dabble in things. Could I bring it myself to speed on it? Have I done it? Yes. It's just, again, my time is better spent doing what I do well, I think, and that's doing hearings. So that's how that works. Mark says, thanks very much. You're welcome, Mark. Michael Chillers, hope all is well. Michael, things are going okay. As you know, I've told everybody I had some issues. My father-in-law fell a few weeks ago. He's doing much, much better. I think we're over the worst of it there. So, I think that those, it's, look, good health, as you all know, if you're in the Social Security disability world, no amount of money, no amount of, of anything else, houses, cars, and other stuff, none of it makes a difference if you don't have good health. And so, keeping your health good is the most important part. And look, as a Social Security attorney, I like to win cases. I like when my clients get a big chunk of money. If we could turn back the clock and give them back their health, 99% of people would say, I'd rather have good health and forget the money. I'll go back to work. And I think that's the way you should look at it. And in fact, that's the attitude you want to bring to your hearings. But yeah, all in all, no complaints. And, I just, my life is pretty good. I got a beautiful granddaughter. I get to play a lot of tennis, family around me. My kids are both around. So I count myself pretty blessed. So all is pretty good. All right, RD is 56. How far back? Good question. Will they retrieve medical records related to the cause of my impairments? Had bladder reconstruction due to domestic complications. Generally speaking, Social Security will look at your onset date, the date you claim you became disabled, and they'll go back 18 to 24 months in terms of what they request. Many times, as you sort of imply here, there could be records that go back longer than that are relevant. Perhaps the surgical records. Let's say that you had a bladder reconstruction 5 or 6 years ago. I think those records would be relevant. So I would get them. You should, either you or if you have an attorney, I would get those records and submit them. Social Security probably will not get them. Now, to be fair, the record that they get, medical records will refer back to things that happen. You're not going to have treatment for a mesh complication without an original surgery. So there will be histories done, and Social Security being kind of an informal system, judges are not bound by formal rules of evidence. They can look at the medical record, and you can glean from the medical record that things have happened. Nevertheless, I like to get those things in the record if I can get them. If somebody has long-term complications, let's say they had a back surgery 10 years ago, or they had mental health problems going back to high school, if I can get those records, I will submit them. I'll get them and submit them. Judge can do with it what he or she wants, but I like to have those in the file, especially in mental health cases. If, let's say, in high school, you were having difficulty in high school, I would get academic records, and that might show you were having, psychological evaluations back in high school, you were having behavior issues, whatever. Now realize, for Social Security purposes, if you got past whatever happened 10, 15 years ago, and you went to work for 14 or 15 years, then their position is, well, obviously you got able to get through it. My argument, of course, is that the residual effect of some of these problems starts to become an issue. I was talking to somebody, I think we had a hearing yesterday on this, and she talked about, she had some back issues going back to really to early adulthood, late high school, early adulthood, and she basically testified to the judge, and we're going to get approved in this case. As time went by, I worked through the pain. I was able to fight through it. But as I've gotten older, it's become more. I'm getting more and more complications, more stiffness, more residual effects of this long ago back problem. And by the time, a year and a half ago, whenever the onset date was, it was getting to the point where it got quite unbearable when you combine that with some other health issues and the stress of my work and some, just a number of other things. So, we were able to, the argument I was making, the picture I painted, the narrative I was creating was that here's a person who had some long time problems. As a younger person was able to fight through it, but as she reached a certain point in life, in her 50s, it became much more difficult to go through it. And maybe, the wear and tear of standing on hard floors, or maybe a car accident, or maybe another, fall where it got tweaked. Then, what was bearable and manageable, 5 years ago became unmanageable, unbearable. And I think that's the narrative, that's the story you want to tell. And I think for a lot of people, that is the case. I mean, as we get older, those things you could fight through at 30, you can't fight through at 50 or 55. And just the wear and tear of life. Look, I played basketball for many, many years, and I loved it. It was great. It was more social for me. I had a pretty good jump shot, but I wasn't going to go to the pros clearly. But I enjoyed it. It was fun. But just the wear and tear, the pounding, you get to the point where I'm wearing a brace, and if I fell the wrong way, I would go into spasm. I'd be out of pocket for 2 weeks, and finally I got to the point where, like, what, it's just not worth it. And I'm playing with people that are 20 years younger than me, that are going to just be a lot more aggressive, and they're going to, they're going to try to knock me down, knock me over. It's just a rec men's league, but some people don't seem to understand that it's a rec league, and they took it a little too seriously. So I kind of migrated to tennis, where it's not as physically demanding, believe it or not, even though there's a lot of running around, not the pounding and just arching your back was probably an issue for me. So, I think I understand the wear and tear part. What I could do when I was 30, can't do when you're 50. So that's just the way it goes. But I think that works that way for many people in job situations as well. Okay, Trish Wade says, good evening, Jonathan and all. Good evening, Trish. How are you doing? Have you ever represented cops for SSDI and generally had a former LEOs? I'm not sure what the LEO, I'm guessing that's something to do with police. I don't know that abbreviation. But I've represented a number of police officers over the years. And, look, I think that being a cop nowadays is, it's first of all, it's a calling. And I think most cops want to really serve their communities. And I have nothing but the utmost respect for police officers because they keep our society going. And, many times they are physically put themselves in danger. It's a very stressful job. I've had police officers who've been shot, been tackled, just all kind of had issues, PTSD issues. And yeah, I think all those things are very, very relevant. I think many judges recognize that being a police officer or working in law enforcement generally, I guess LEO, law enforcement, okay, that would make sense. Law enforcement in general is going to be inherently stressful. Many times you are out-armed, outgunned, and every day, you could find some nut who's going to pull a gun on you. And so I think that judges realize there's an inherent stress in that. And, it's one of these things where, you're asked to do physical tasks, tackle people who don't want to be tackled, and, chase people. And anytime you do anything, you're putting your life on the line. So, yeah, judges, I think, respect that. And I've had pretty good results in that regard. Now, you still have to have, something significant. I will also tell you that sometimes when a police officer has a medical issue, physical medical issue, there may be a workers' comp element going on there too. They got hurt at work because of something that happened. They got, in a car accident or in a vehicle accident, or they got, they were tackling somebody and they got hurt. And so workers' comp can make a Social Security case very complicated because there's an offset there. But sometimes you have police officers who do get hurt off of out of the off the job site, off the job, and in those situations, there's no offset there. But yeah, I think most judges are pretty open to it, and I think it's my honor to represent a police officer, quite frankly, because like I said, I just think that you don't have law enforcement, then our society falls apart. So that's my take on it. So yes, I have, and I'm happy to do so. More of it too. Rodney is one of my longtime clients. How are you doing, Rodney? I hope all is well with you. William Spillman, maybe. Hello from Texas. Hello, William. I hope you're doing well. Bala 2001, good evening. How are you? Tara, how are you doing, Tara? One of my clients. George, say you're 66. Okay, let's hypothetically say you are 66. Not that you are, because you look a lot younger, but let's say you are, and you want to work. Well, you need to tell SSA do the trial work period. Yeah, well, I think the trial work period is going to be automatic. Well, first of all, let's back up. So you're 66, you're getting really close to retirement age. And once you hit full retirement, Social Security disability transitions over to retirement, you can work without affecting your benefits. So one thing to think about here would be to find out when your full retirement is and just maybe wait until that point. That way there's no issue. But let's say that you decide, okay, I want to go back to work. The first 9 months, and again, assuming you haven't worked before, are automatically trial work period months. You don't have to do anything. It's just automatic. And then once you get beyond that, you need to stay below SGA. And you're supposed to report your earnings by uploading, they call them payment advices to your My Social Security portal. So that's what you would need to do, is just update the portal. They say they should do it monthly. I would tell people monthly, every 2 months, something like that. But again, the question here is, if you're within 4 or 5 months of full retirement, it's not going to make a difference, because if you haven't used up your trial work period, you'll be still in trial work period when you transition over to full retirement. So yeah, and I think wanting to work is a good thing. Obviously, it's unlikely they're going to trigger a review. By the time you get a review, you'll be at full retirement anyway. But the question here is, do you want to create any kind of glitch in the matrix, as it were, that would create a problem for you, or is it better just to sort of sit tight for a couple of months and wait till you're full retirement? My thought with Social Security is, don't poke the bear if you're really close to being in a situation where it's all irrelevant, it's all moot. That's my take. Okay, Justin says, hearing is set for August, judge as 60% rate. I would be optimistic too. That's a very good place to be. You want judges that are, over 50% at 60%. That's a good thing. Now, realize there are situations, and I've seen it happen, where you go into the hearing, all of a sudden Judge 60% got replaced by Judge 30%. So you definitely want to be prepared. And as an attorney, I assume the worst. And it's happened to me. Well, actually, it's happened more often to me that a low-paid judge becomes a high-paid judge than the other way around. But every once in a while, you get, it used to be I'd walk in the hearing office, like, I thought we had Judge so-and-so, and I got this, this guy who didn't pay anything. It doesn't happen very often, but it could happen. So I'm always prepared, for the worst. But so I wouldn't assume anything. And even a 60% judge will deny cases if the medical's not there. So you want to make sure that you and your attorney are both prepared. But that's a good place to be at this point with a 60% pay judge. Okay, Leanne is in reconsideration stage 4. And as I mentioned, the whole stage 4 or 5, that doesn't mean squat. It's just a phrase they tell you. It doesn't really mean anything. It says that your claim has been sent to your local office to see if I'm still eligible for the non-medical portion. I talked about this a little bit earlier, Leanne. They want to make sure you're not working, because realize that disability is a vocational question. And so if you apply for disability and you meet the medical part, you are medically disabled because you got a serious medical condition that prevents you from working. But unbeknownst to anybody, you went back to work, or you took a volunteer job that is SGA, okay, then you are no longer eligible. So they're going to need to make sure that you are not working or doing anything that would take you out of eligibility. And that's what they're doing. They may also be looking just to double check the earnings record to make sure that's really you. And again, every once in a while, very, very rare, somebody will come to me and they'll say, well, my earnings record shows earnings from someplace I never worked. Um, and what should I do? And again, I think you probably should tell them that, because it's going to get caught eventually. But that's another more rare issue. But usually it's just to make sure you're working. Marcinelle Monroe. When I call to check the status of my case, automated service says having trouble processing my request. What that means is that the automated system is broken. They don't have enough people to answer the phone. The system has not been updated. And this is the reality of what we're dealing with, is a really, really broken system without enough people, and technology not really being caught up to date. So this is just a bad place to be. I mean, we don't even bother trying to call anymore because you can't get through. And last time I called Social Security a few weeks ago, I was on hold for 45 minutes and I got disconnected. So that's just the way, unfortunately, it is. Madeline of my office. Good evening, Madeline. Good evening to everyone, she says. Hello, Madeline. Hope you're doing well. Madeline in Oklahoma. Spine surgery journey. Just had my medical evaluation, and it was nothing about my injuries. The focus was on your meds. Again, I would tell you that I would write down some notes as to what happened. Because if you had a consultative evaluation and you've got back issues, and they didn't ask you about, standing, walking, bending, stooping, did do any neurological testing, I think, if the report comes back against you, and I would try to get a copy of that report, your attorney can do that, and eventually you'll get it if the case goes to a hearing. But if you have notes that you've taken about what happened, and let's say the report goes against you, at the hearing, your attorney can basically say, Your Honor, my client went to a medical consultative, which is exhibit 19F, in May of 2025, and here is his statement, which is already in the record. His statement is going to be at 15E, where he basically talked about that the doctor did nothing in terms of neurological testing, reflex testing, and the only thing that he asked about was medication side effects. Yet this report goes into detail of all these things that didn't happen. We would ask, and the claimant will be happy to testify about what happened at this hearing, we would ask the court to give this opinion, which again is presumably not in your favor, little to no weight. And that's the way you deal with it. But it's important to have a contemporaneous reference note about what happened at that consultative evaluation, because 2.5 years from now, a year and a half, you're not going to remember what happened in May of 25. But today you do, because it just happened a few days ago. So write down what happened. I would recommend. Jen from Nebraska is my main paralegal. She is here. Hello, Jen. I know you called me earlier and I was feeding the baby, so I couldn't talk to you. So we'll talk tomorrow, of course. But good to see you here. Stargirl, how important are pay stubs to prove frequent absence? I'm having difficult getting them. I have an FMLA copy. That'd be enough. It doesn't matter if you quit versus getting fired. I mean, I think that, if you can get an employee file, that should show a lot of that. Again, this is an area where you could write down on a calendar the days you came in late, left early, or missed altogether. That becomes evidence, even if you don't have any pay stubs or anything like that. FMLA paperwork would be helpful as well. Your testimony and your calendar could be evidence. So I think that would be enough. And as far as quit versus getting fired, I don't think it's a huge difference. I mean, getting fired probably has a little more resonance with the judge, in that, okay, you were terminated from your job because of performance or attendance or whatever. But I've also had a lot of people say, well, I had a lot of pride in what I did, and I know I wasn't pulling my weight, and I talked to my boss, and he agreed to let me resign, with the understanding that I could use that resignation so that if I get better, and I do hope to get better, when I go back and try to find another job, it doesn't show that I was fired. It can show that I resigned, and I can tell a potential employer I resigned because of medical issues. I've worked through those, and now I'm ready to get back to work. So if that's something that you think might be helpful to you, I don't think it makes a difference. And again, when I have my clients testify about resigning, I may ask them, why did you resign? Many times it's just I wasn't doing the job. I was putting my coworkers in danger. they were resenting me, or I wanted to have on my record that I resigned so that I could, get back in the workforce, and it would not show a termination on my record. And I think that's a perfectly legitimate reason. Okay, spine surgery had well, I assume obviously you had surgery because that's your name of your YouTube handle. Had C5-6 fusion, L4 and 5 and S1 fusion. Medical didn't talk about the injuries, 55 and 34 years. Again, at 55, certainly you could grid out if you're limited to light work. But before 55, between 50 and 55, which is my guess when your onset was, you could look at the sedentary grid rules, the 201 section, and you could basically say, if I'm limited to sedentary work, which again is standing and walking no more than 2 hours. And so again, with all these, back issues, you probably could make that argument. Lifting 10 pounds frequently, or 5 pounds, this is sedentary, 5 pounds frequently, 10 pounds occasionally, you might grid out at sedentary. Therefore, you could be approved then. Certainly, as of your 55th birthday, your chances go up because now we have the light grid rules that apply. So, you don't want to give up those. Let's say you applied your onset date, you were 54 or 53 in 10 months or something like that. You don't want to give up a year and a half of past due benefits. So this is where I find that Social Security tends to, let's just move you to the next age category so they can, not pay you the past due benefits. That's the decision you've got to make. But like my client, when I've got my hearing tomorrow, spine surgery, same sort of thing. I don't think that you're going to get denied if they should screw with the onset date, but just be aware of that might happen. You want to be prepared for that should that happen. But I think your chances are all pretty good based on what you're writing here. L. Brown says, excellent. Thank you, L. I appreciate you. Blue City Garage, who's been here before, after 21 months, still at the initial stage. Had a CE, I'm assuming a physical CE 2 months ago, and then they said I need an eye exam. They set an appointment for July 2nd. After contacting my center, you see things start to move. And again, a vision exam is, going to determine whether you have problems, after correction with near or far vision. And if you look at everything in Social Security disability through the lens, if you pardon the pun, of how it affects you at work, if you have, let's say, lack of peripheral vision, let's say that's one of your issues. Let's say you're diabetic, you have lack of peripheral vision for whatever reason, macular degeneration, then jobs that would require you to be on unprotected heights or around hazardous equipment would be eliminated. So now we carve off entire categories of jobs. If you have difficulty reading small type, then that might eliminate certain clerical jobs or jobs that require reading. Or looking at written instructions, that might eliminate those. If you have problems with after correction, seeing distances, that would eliminate jobs that require driving, either a motor vehicle or a forklift or something like that. So again, everything in your file, everything you're alleging as a disability, you want to link it to some sort of element of job performance. That is the main issue here. And if I had to tell you, the one thing that I try to really explain to my clients early on, and I know Madeline and Jen do this as well because we talk about this a lot, this is really about work capacity. This is about your ability to function at a job. So any problem you've got, any medical problem, what does that mean in terms of your working? Spine surgery journey has had multiple surgeries, cervical in the neck, lumbar in the lower back. What does that mean? Does that impact him? If he testifies, well, I can only stand for 10 minutes at a time, I can only walk for 15 or 20 feet, then I've got to stop. That's consistent with having these surgeries, assuming that the record indicates the surgeries are not entirely successful or the scar tissue has formed. It's a consistency there. So if his testimony is, I can't stand for more than 10 or 15 minutes, I can't walk for more than 30 feet, I can only sit for 15 or 20 minutes, and I've got to lie down 3 times a day for 30 or 40 minutes to get the pressure off. And the record shows multiple surgeries. There's been revisions. There's, recurrent herniations. The fusion was not stable. All that is consistent. And that's how you win cases, because you have medical issues that are consistent with those functional limitations. So when you think about applying, when you're looking at applying, look at your medical record, think about the problems you've got, what are the work implications? How would this affect you at a past work as well as any other kind of job? And again, any job requires a certain level of attendance and reliability. And at every hearing, just about, vocational witnesses will talk about off-task behavior, meaning that if you are off task because of pain, because of medication side effects, more than, some say 10%, some say 15%, let's just use 15% of the workday, that is excessive and would preclude competitive employment. Similarly, the vocational witnesses will all say that, like I had one hearing yesterday, the VE said for skilled work, 1 day of work per month is the maximum that somebody could have, they could miss. For unskilled work, 1 day every 2 months. Anything more than that would be work preclusive. So again, if you've got evidence that says, you have really, really bad days, whether it's the weather, humidity, just, you overdo it, whatever it may be, and there's evidence that you have bad days, 3 days of work, 3 days per month, you have terrible migraines, you've got back pain, whatever it may be, then that would be work preclusive if the judge accepts that limitation. Obviously, the medical evidence would be really helpful, but your testimony can be helpful too. My case yesterday, there was solid medical evidence, but my client's testimony put us over the top. So, but again, look at everything through the lens of how these medical problems impact you in a work environment, a potential work environment. And think about not just your past work, but think about a simple entry-level brainless job. I mean, literally something where you're sitting there. There's actually a video I sent to my staff. I'll see if I can find it and show it to you next week. It was this guy basically sitting watching an assembly line. He was like patting things. I mean, this is like he was on his phone as he was doing it. I mean, there are jobs that literally, if you have a room temperature IQ and you can sit there all day long, sit or stand, you could do these jobs. And that's what you got to look at. So, you have to have a real clear idea. I'm a big believer, and I always talk about having a narrative, but even beyond that, you got to know what you're trying to prove. When you go to a hearing, you've got to understand what message you're trying to convey to the judge. Not that that you've had terrible financial problems because of not being able to work, or not that, not working has caused family issues for you. That's not relevant. It's how your medical issues prevent you from doing any kind of job, despite the fact that you want to, despite the fact that you're getting pressure from your family, that if you could do anything, in the world to get back to work, you would do it, but you can't. Again, you want to tie those medical problems with symptoms that are consistent with those medical issues and the medical record, and tie them to specific limitations. That is how you win. Okay, and Shub, this is the person who asked about, the onset date and back pain. And so, again, this is another issue that pops up a good bit, is if you have long-term disability, most of these long-term policies say you're required to apply for Social Security. If you win, any months that the long-term disability, paid you, that you also get back pay from Social Security, you've got to sign that back pay over, less the attorney's fees. So in effect, the long-term disability, in Chubb's case, Hartford would be paying my fee because they don't make him pay back the part that was used to fund the legal fees. And then the nice thing about having Social Security, even though it doesn't mean any money for you right now, number one, if Hartford or the long-term carrier decides to play games down the road, then you've got the Social Security as your backup. And secondly, you get cost of living increases. And third, you get eligibility for Medicare 2 years after your first eligibility for payment. So there are, practical reasons to pursue Social Security when you've got a long-term disability policy. I've got a new client, for example, I just talked to the other day, and she was telling me, and her thought was, and I'm not sure if it's right or not, we're going to look at it, that there's only a 2-year payout on long-term disability. I'm thinking the definition of disability is own occupation for 2 years, and then she would remain on disability, long-term disability, if she couldn't do anything at all. But it may be, the policy says something I don't think it is. But I said to her, it makes sense to get this, even though you're going to have to stroke the check back to the long-term carrier. Now you have backup. Now you have the long-term disability plays games with you. We have something to fall back on. You've got Social Security, and then you also have Medicare. Okay. Good evening, Vince. Vince is one of my clients. Hope you're doing well. Vince tunes in almost every week, and it's good to see him. Hope it is warmer where you are. Vince is in a very cold. I always forget where you're at, Vince. Michigan or Illinois or some point, Wisconsin. I know you tell me every time, and I forget, but it's cold. But I hope it's not cold there now. Okay, Blue City. Thank you for your advice to contact. You think they're working hard to approve me. Song and dance to stretch others now. Contact if you received it or not. You know, I don't assume anything. I mean, you see something online that says you're at stage 4 or doing a non-medical review. Until you get the piece of paper in your hand that says you've been approved, I don't assume anything. I don't think you can assume anything. I think that, you know, a lot of stuff Social Security tells you is to pacify you, is to make you feel like something's happening. Um, I don't need to be overly cynical about it, but they're not going to volunteer anything. So I would tell you that, until you get that approval in your hand and it shows an approval as of your alleged onset date, don't assume anything. Maybe you could be cautiously optimistic because they're saying they're doing a non-medical review, and based on all the factors, you've got a winning argument. Again, until you see it, don't believe it. There's an old saying in law school that an oral or verbal contract is worth the paper it's written on, which means that, if you look at the case law for contracts, verbal contracts, even though they're theoretically enforceable, it's very hard to prove them. This person, said he would sell me, that TV for $150, and he doesn't refuse to do it, and you sue him. I didn't say that. Well, his word against your word. So until you see it in your hand, don't believe it. Sam the Man is 61 years old, out of work on long term for 18 months for herniated disc. Right there, I think we can all see Sam is 61. So that tells me that the grid rule for light work would be implicated here. Herniated disc is physical, whereas the grid rules only apply when you have physical or exertional limitations. So he's been out of work for 18 months. He's got long-term disability, so if he gets Social Security, they will expect him to pay back for those months he got long-term disability. But again, if you've got an attorney, Sam, the attorney's fee will not, you won't be paying anything because the long-term disability carrier will pay it because they won't make you pay it back. It benefits them to get you on disability because it reduces what they have to pay you. They will pay you, whatever they pay you, they reduce the Social Security part because you're getting checks from Social Security and long-term. Again, the reality is if you got approved for disability, Social Security, you won't see any change in your life because the same amount of money is coming, partially from long-term, partially from Social Security. But what will happen is you'll have no backup in case long-term decides to play games again. Like I said, you'll have Medicare at some point, and you get a cost of living increase. When Social Security cost of living goes up, the offset doesn't apply to the cost of living. So you'll see a little bit of an increase in your monthly take. So, I think you're in good shape if you decide to pursue this. All right, Strawberry Mandalorian Shorts. I'm 100% permanent and total VA disabled for PTSD and other ailments. How steep of a climb is the SSDI for me? Question is, how old are you, Strawberry? That's one question. First of all, as you all probably know, the VA determination of disability is not binding on Social Security at all. So even though you have two agencies of the federal government, the Veterans Administration, Social Security Administration, totally different standards for disability. The VA tends to look at disability in terms of percentages and body parts. Social Security is all or nothing. You're disabled or you're not. Being 100% means you'll be at the front of the line. So your case will be evaluated faster by Social Security. They will recognize that you've got 100%, but it's not binding on them. PTSD, like any mental health condition, is hard to win on Social Security because it is an invisible illness. You can't take an MRI and see PTSD. So it's going to really come to your testimony and other evidence you can get. The other issue is that, at the VA, if you're getting treatment at the VA only, many times PTSD is treated with group therapy. That is less desirable in terms of getting, real detailed notes about how you're doing. I tell people in this situation, it might not be a bad idea to seek your own independent exam with a psychologist to evaluate you for work limitations. I think the VA, the one thing I do see positive about VA cases is they tend to over medicate. So you'll have a lot of medications, many of which could be, you know, um, make you sleepy or dizzy or drowsy or whatever. And so that can help you. PTSD, the VA, even 100%, you've got to show a extremely high level of impairment, whether for PTSD, and I mean, the triggers have to be really, common things like, loud noises, lights, voices, whatever. I think that Social Security judges a lot of times want to hear about the trauma that you had. A person who is in combat for 12 months and saw, you know, friends and colleagues blown up on a regular basis, for a year, that's a whole different ballgame than somebody who was serving and they got injured after 3 weeks and, they're claiming PTSD. Not that it can't happen, but, they tend to want to see trauma that's more of a long-term kind of thing. And the trauma needs to be pretty significant. Again, being around dead bodies, have seen friends blown up, things like that. Also, like any mental health condition, the level of severity. Have you had multiple failed medication trials? Have the doctors at the VA or elsewhere tried multiple different medications? Have you had suicide attempts, which again, really serious, something shows something very, very serious. Have you been hospitalized inpatient to stabilize you because you had a breakdown of some type? You've got to really prove it's at a level, because remember that the grid rules don't apply if it's just mental health. You've got to prove that your symptoms would prevent you from doing even a simple entry level, walk around, warm body kind of job, and that's a high burden to meet. So it is difficult. Spine. This is a very good question. He asks, spine surgery journey. Does Social Security use the grid rules automatically have to tell them to use it? In theory, they should know at the state agency how to use it. In practice, they often do not. So when I'm doing an appeal, and certainly at a hearing, I will specifically talk about the grid rules. I will ask them to, I will give them the grid rule to apply. Look, anytime, no matter what it is, whether it's any kind of legal matter, if you can offer the decision maker a clear path to approve you, and by that I mean, here's the grid rule, here's the theory of disability, these are the disabling impairments, these are the side effects of medication, this is what WebMD says, it makes their life a lot easier. They can justify what they've done. So I think that in that situation, they should know how to do it automatically, but they may not. Therefore, you need to tell them. I'm giving you in the crawl there a link to my website about the grid rules. So if you want to talk, reach out to your adjudicator, look at the gridrules.net site and find the grid rules that apply. It might be multiple. They may say if I'm limited to sedentary work, it would be this one. If I'm limited to light work, it would be this one. Give them a couple of options. So like when I do my briefs, I'll say, look at, grid rule 201 point whatever. Look at grid rule 202, if limited to sedentary work, if limited to light work, look at grid rule 202.06. I will tell you, decisions, it's really interesting. What I notice is that many times what a judge will say in a favorable decision is, I'm finding this person disabling because the combined effect of his or symptoms so erodes his functional capacity, there's no jobs he can do reliably. And then they would say, however, even if this person could do sedentary or light work, grid rule 202.06, directs a finding of disabled. So they will usually see the grid rules as kind of a secondary thing. So I've changed the way I brief them now, where I'll say, we think the functional capacity reduces all work, eliminates all work. But in the alternative, if you find these limited to sedentary, look at this grid rule. If it's to light, look at this grid rule. That's the way they seem to look at it. So that's what I would tell you. I would think It's a very good question. I would say, I would definitely let them know what you want them to do and give them, give them direction if you possibly can. Strawberry says he or she is 100% VA disabled, lives overseas. That's not as big of a deal as you might think. I mean, assuming you're not in North Korea, as long as you're in a country, Mexico or in Europe or something like that, they have an international office, so you can still pursue disability. All right, Sam is being represented by a third party. The attorney will call me the day before the hearing. That'd be enough time to prepare. So you've got what they call non-attorney rep. And I sometimes what I see is these cases where they're assigned to Brown and Brown. They're assigned to a non-attorney rep firm, and those firms don't have they don't have staff lawyers. They will find a lawyer to appear at the hearing. I've done those cases. I used to do work with Brown and Brown. I've done work for a couple of other companies over the years where I would do contract work. Again, you don't have as much to lose because if you lose the hearing, you still have your long-term disability. Is one day enough? No. Perfectly honest with you, it's not. I've had people, terminate some of these non-attorney rep firms and bring me in because they want to feel more comfortable with what they're doing. But again, there are, the attorneys that they get, they can be really good or they can be somebody who doesn't really care. You just don't know, and you're not going to know. Now, again, when I was doing work with Brown and Brown, and I think they did a really fine job, by the way, in preparing the files for me, they would let the client know about 3 weeks out, and they would give that information to me. I would reach out to the client 2 or 3 weeks out so I could do my normal pre-hearing prep. And if there was something that needed to be updated, they would then update it for me. So they were sort of kind of serving as my staff in that regard. It would concern me to find out you're going to hear from your lawyer the day before. I think you need a little more time than that, personally. But it may be that your case is so strong it's not going to make a difference anyway. You may have a really, really good judge. But at the very least, what I would tell you, Sam, is maybe reach out to this third-party rep firm, that they're dealing with this, and say, look, can you give me the name of the lawyer a little bit early? I just want to talk to him a little bit early. Make sure there's some sort of rapport. Make sure I'm comfortable with him or her, because it's a pretty scary proposition to me. I mean, if I was in your shoes, I wouldn't want to hear from my lawyer the day before the hearing. I'd want to have some opportunity to really talk to that person. And the way I do my pre-hearing conferences, whether it's when I was doing repping for some of these companies or doing my own, my pre-hearing conferences take an hour, hour and a half. It's not, and you need to spend a little time. You got to make your client comfortable. You got to feel comfortable with that narrative. Again, day before, yeah, I've had that happen. Not ideal, but it has happened. So it's just going to be, I would just leave it at this. Try to find out who the attorney is and try to reach out earlier. That's what I would tell you. Nice. Thank you. Nice. You don't have to beg pardon. Any question? Will Social Security turn to retirement at 60, at full retirement age? Yes, it will. It will. That's automatic. And Andrea says, yes, would rather have your health and life back. I totally agree. Totally agree. Kelly is at Recon. 8 months, has a new doctor, new condition. I had to report that to SSA. I just do it, honestly. If you look at the bottom of, you've probably gotten a letter from your Recon adjudicator. At the bottom of the letter it'll say like K. Anderson or S. Jones or something like that. There'll be a phone number and a fax number. I would just fax a note, fax a letter. Dear Adjudicator Johnson or Jones or Smith or whatever, please be aware that I have a new doctor. Here's the name and address. I'm also being treated for a new condition, cardiac arrhythmias or whatever it may be. Please, and I would also give updated, if I've gone to the following doctors since the initial denial, please obtain these medical records. Honestly, that's what we do. If we have, that's what, Jen would tell you. What we do is if we have a client who's going to a new doctor, has a new condition, we notify the adjudicator either electronically If we have electronic access, we'll write a letter and we'll upload it to the ERE system or by fax, and we'll say, here's something new, and you need to develop it. Let them do the work. But yeah, let them develop. Let them develop it, but you need to let them know in writing. So if later on down the road somebody says, "Well, you never told us," you've got proof. You got proof. Um, but yeah, that's what I would do. Just do it in writing. Fax is fine. Um, Susie B. Hi, John. Thank you for all your share. My pleasure. Question is there an SSI form to fill out? You receive SSD and soon to be workers' comp. Workers' comp says, so it looks like you're about to settle your comp case. Once the payment starts, there's an 80% rule. Yeah, basically there's a rule that talks about how much you'll get, how much the offset would be. If you're about to get temporary TTD or temporary total disability benefits, I'm not aware of any form in particular. You could use the SSA 795 to do it, or you could just write the Social Security and say, I'm going to be receiving TTD benefits of this amount starting at this time, and they'll have to make the adjustment to what you get from Social Security. And obviously, it's a little bit unusual because I assume you've been fighting to get TTD for a while, because if you're on disability, you would not have been working to have gotten injured. So obviously, this is something that's been going on for a while. So I would honestly, given those circumstances, there may be some past due TTD. This may be a situation where your attorney needs to really look at this. Maybe I'm just throwing this out. If you settle the case and all the past due TTD is put into the settlement of future medical care, and you have a Hartman language in there that basically says we're only going to reduce your SSD by the amount of your a percentage of your weekly benefit based on your lifetime of earnings or your expected lifetime, it may be more to your benefit not necessarily to get those TTD checks or a big lump sum representing past due TTD. Just throwing that out, because you might be able to make your Social Security go further by not having it. Again, talk to your comp lawyer about this, and hopefully the comp lawyer knows enough about Social Security to know where there's that risk. But look at this from a bunch of different angles. What happens if you start getting TTD? What is that going to mean? Are you getting any past due TTD? Because presumably, if you've been fighting this for a couple of years, and they picked it up, they're going to owe you a big chunk of money for the past due. Well, that's going to mean that all those months that you've gotten Social Security for the last 2.5 years, that could be a problem. So whereas settlement might be a way to kind of put it all into one big pot and use the Hartman language to not make it count against you. Again, just something to talk to your comp lawyer about. So I would just don't assume anything, but realize there may be different strategies for claiming the TTD benefits. Paul Nightwolf, how often we hit 55 that you reviewed for continuance? I'm not seeing statistics, Paul, but my experience has been unless they see earnings, if you have earnings, then that might trigger a CDR, continuing disability review. But if there's no earnings, probably not very much, because again, you're not the target of who they're going after. They want to go after the people who are younger, who are going to be pulling on this from the system for the next 15 or 20 years. If you're 55, you're going to be pulling from the system another 10 years. Not insignificant, but the fatter fish to go after are the ones who are going to be pulling out off the trust fund for 15 or 20 years. So it's not very often unless they see that you are working. RFT is 58, had bone on bone in both knees, hip osteo, degenerative disc disease, and stage 3 osteoarthritis spine. Want to file for disability, scared you'll get denied. I mean, anybody over 55 with documented orthopedic problems, I'm looking at this saying grid rule, grid rule, grid rule. Not every one of those cases get approved, but that formula, a person over 55 with documented, exertional problems that are orthopedic, and you've got MRI evidence to show some of this stuff, how hard is it going to be able to prove that you can't stand and walk for 2 hours in a day? You can't lift, 15 pounds. I think those cases get approved all day. That's my bread and butter. I love those cases. So to me, I think you got a good shot. Could you get a judge who doesn't believe in disability? Sure, that could happen. Are there some unusual transferable skills you've got? You're on no medication. I mean, there are any number of things could make that less attractive, but I think overall the model is pretty good. So I think it's a good case. Brian Harris has got ankylosing spondylitis, which is like a condition where you kind of have a fusion in your spine that is just sort of happens naturally. It's a very painful condition. I was actually there's a ankylosing spondylitis Facebook group, and I got interviewed for a podcast a couple of years ago by the head of that. So I've had a number of AS cases, and those can be strong cases. So on Social Security in California, SDI since '89, neck is back is fused. Mom died 2 years ago, left me some cash. All right, so you're SSI. SSI has an income and resource limit, so that was the problem there. Now, the thing to ask would be, is there any way to put that money in some sort of a trust that would not offset your SSI? There are different types of trust. Now again, whether it's worth spending the money to put a trust together for $2,800, maybe not. But I know, actually, I was talking to another disability attorney out of Chicago yesterday about this very issue, and we were talking about different trust options. So, a trust might be a way to go if it was worth it money-wise. Okay, Ihala, how long do you have to be out of work? The day after you stop, 1 day. You can, as soon as you make the decision or you have a good faith belief that you're not going to be able to go back to work for up to a year, for at least a year, you can apply. Remember, disability by Social Security is defined as a medical condition or conditions that have lasted or are expected to last 12 consecutive months or result in death. That's the duration requirement. That leave you without the ability to engage in substantial gainful activity. Then it's documented medical problems, going to last at least a year, keep you out of work for at least 12 months. That's the definition of disability. So, it's given that the time frame for many disability cases is 2 years. If you apply the day after you stop working, yes, technically you have not been out of work for a year, and at the initial and recon level, they may turn you down because you're not been out for a year. However, the reality is most cases are turned down at initial and recon. I think the value proposition of applying sooner rather than later makes sense. If your condition is really, really severe that you would be approved early because it's listing level, they will assume you're going to be out for a year. Those cases that are not listing level are probably going to get denied anyway. So let the time run while you are applying. And then once you hit a year, you could go for, at the hearing, ongoing disability, or in some cases, if you go back to work, a closed period. But my feeling is start it sooner rather than later. That's what I think. Okay, that's where to get a case evaluation. John Zima. Hello, thank you. My pleasure. I hope you're enjoying it. You said earlier you're trying to get 50 to 60K of past due benefits for your client. I thought this was capped to 12 months prior to application. It is, but realize he applied like 3 years ago, 2 or 3 years ago, and alleged an onset date, let's say a year before that. He gets approved at initial using the changed onset date. We appeal. It's taken 2 years to get to a hearing. So when you look at the 2 years from the time he was approved and go back to his application, which was a year before that, then going back another year, they're like 4 years at stake here. So yes, it's 1 year prior to the date of application, but this whole process has been, it's a 3-year process, plus a year prior to the date of application. So that's where the 4 years comes from. If you're an SSI and somebody who leaves you money, you have to report it, otherwise it's an overpayment. Yes. But again, could you use some sort of a trust instrument to deal with that? Sharon, how are you doing, Sharon? Ironically, Sharon, I talked to somebody today who is from the same part of the world as you are. We were talking about the cuisine that we both we enjoy, and this person has, I think, is a pretty good case. And she mentioned that she'd seen the live stream, and she may be on here, and she recognized the name as being native to the country you're from. And so I just was saying, so it's interesting. In your case, we got an approval. The judge called my office the day before the hearing and said, we're going to approve that case. Now we're trying to get your money. They're dragging their heels at that, but we'll get it. But it's just kind of interesting that, your name came up is my point. And of course, I don't discuss your particular case. She just said, I saw you had somebody on there that the name rang a bell to me in terms of the ethnicity of it. So your name did come up in a positive way today, Sharon. So I hope you're doing well. Kimmy, sir, Mr. Jonathan Ginsberg. Well, I'm not a sir. Thank you for the video. My question, if I get this, really should be first interview for the SSDI. You don't have to go back and get interviewed or requalify every year. Once you're on disability, they assume that you're disabled until they move to cut you off. So there's not a yearly review of anything. You're on disability, you stay on until they decide to cut you off or they try to cut you off. Angel, Angel says, I guess it's Angel says, I'm 53 and have maybe depression. You mean schizophrenia? Will reconsider my case? It's in the light of something I'll take it. Send a letter by May 4th. It's hard to give you how long it's going to take because it just depends on how busy the office is and what information they're gathering. The general rule of thumb is that initial, 9 to 12 months, recon, maybe 8 to 11 months, hearing 5 or 6 months. But it's going to depend on how busy the office is that's handling your case. And I just can't really give you any particular time frame other than that. I'm sorry. Block's fruit picture. At the price I'm paying for health insurance or other crap, I'm about to go back to work. It doesn't make sense. Yeah, I hear you. I mean, this is a real problem. Is they make you wait so long, and sometimes you have to go back to work. In which case, I'd keep your Social Security and application going and go for a closed period. And because realize you go back to work, it may not work out. And if you have to leave after 3 months, that could be a failed work attempt. So either a closed work period or failed work attempt. So I wouldn't stop your disability application, but once you hit 12 months out, now you can at least go for a closed period. I've had cases where, we go for a closed period. My client gets a lump sum of $15,000 to $20,000, for the time they were out, and they're back at work. At least they've got $15,000 or $20,000 they didn't have otherwise. So that's worth it. L. Brown says, receiving Social Security for 2 years, also receive Medicare. Okay, and you can add supplemental insurance. It's 2 years from the date of first payment. So realize there's a 5-month waiting period. After that's over, you become eligible for payment. So if you became eligible for payment, not your onset, but you're eligible for payment in November of 2024, December of 2026, you become eligible for Medicare. That's how that works. It's not based on your onset or date of application. It's based on the date 5 months after you are found to be, you become eligible for payment. It's the best way to put it. It's eligibility for payment. No Sky says, hello, Jen. And just so you know what you're talking about is Jen, my paralegal, her daughter-in-law has deemed my staff people, the Gloden girls, GLO, Ginsberg offices, as kind of a plain words for the Golden Girls. So we're always joking about who's B. Arthur's character, who's Rue McClanahan's character, who's Sophia's, the different women on Betty White's character, who the different women are. Estelle Getty was the other one from the Golden Girls. So that's what that's all about. So just so you know, this is sort of an inside joke with my staff, but they are. That's what they are. Okay, Ronaldo Productions, thank you for all the knowledge. My pleasure. Chan Tet, hello, Chan. 49 years old, waiting for reconsideration for 9 months or longer. It's hard to say. You're at the point now where you should be getting a decision within the next few weeks or months, certainly the next couple of months, but I would probably tell you to reach out to your U.S. Senator at this point. 9 months is I think anytime after you get after 5 or 6 months, I would probably tell you it's time to reach out to your senator. If you sleep 19 out of 24 hours, yes, that is disabling if you can prove that. Absolutely. If you have that level of sleep, how are you going to work? You can't. But proving that is the question. How do you prove it? RD says, I missed a lot of work with few surgeries part of my onset date. It was self-employed hairdresser. Will medical history show SSA? No, it probably won't. It may reference it, but I think what I would do is I would go back and look at your calendar and see how many days and make that a document, put it on Form 795, or just even on a written document to talk about how many days of work you missed. If you can have a former coworker or somebody who had a seat near yours, a chair near yours, talk about how much you missed, that would be helpful as well. Don't assume that your medical record is going to talk about your missed time from work. Spine surgery says I've been disqualified from my job due to my injuries. I have a QME rating very high, disabled from my. Yeah, I mean, again, those are all things that are going to help you. They're going to help you, but realize Social Security is not about not being able to do just your past work. Let's say you were a truck driver and you can't pass the physical, or you're a police officer, can't pass the physical. That is not going to mean you're disabled for Social Security purposes. It may have grid rule implications, it may have other implications, but it doesn't mean you're disabled. You have to prove you can't do anything at all, unless you're in the grid rules. Like I said, it could have implications there. Yeah, I think L's a good point. Your spine is a ladder with damaged rungs. Yep, good way to put it. Jackie. Okay. So Jackie's husband is a client of mine. We won his case recently. We're now in process of getting it all paid. We are doing well. We just got the ALJ approval letter in the mail. Because I'd sent it to you by email, so you should have already seen it, but it just came in the mail. In fact, I was in the office today. I just the person who normally opens the mail was out today, so I opened all the mail today and scanned it to one of the other staff people. And so I saw that decision, so I got it in the mail today as well. Processing center to do has to go ahead and do its thing, so you'll get paid. But that should happen the next week or two. Yeah, by Carly Simon. Only generally, yeah, that's true. Carly Simon, for those who don't know, is a singer-songwriter. She's probably in her 80s at this point, and she had some big hits. Haven't Got Time for the Pain, Anticipation. What's the one? The big hit she had, where she's talking about, I don't know why I can't. Now I'm thinking about it. I'm not going to start singing. So she did You're So Vain. That's the big one. Nobody Does It Better. That's the way I always heard it should be. Anticipation. So she had some big hits. She was married to James Taylor for a period of time. They had a couple songs together, but You're So Vain was her big one. A very talented woman. Interesting story about Carly Simon. Her parents, her father was the Simon of Simon and Schuster book publisher. So she's a singer-songwriter, but she grew up very, very wealthy. Father was a big-time book publisher. And, yet she forged her own path and again, a very, very talented singer. Really did some really neat stuff in the 70s and 80s. And she's still active, but I think not as much in terms of new stuff. But Carly Simon, if you have not heard of her, just do a quick Google search on her and listen to some of her music. She's a really, really has a unique voice. And again, you probably have heard You're So Vain. That's the biggest hit that you hear on radio a lot. But if you haven't listened to it, give it a listen. There's some, it's interesting. My kids are in their early 30s now. And I know I don't look that old because I had kids when I was like 15. So, and my son in particular has got a pretty good appreciation for classic rock. But a lot of my kids, we'll call them kids, young adults, their friends have not heard some of the really fine musical artists from the 60s and 70s. In fact, if you go on YouTube, there's all these channels of they, people, college student for the first time hearing the Rolling Stones or the Beatles or the Who or something like that, and they kind of give their reaction to it. And if you're younger and you've not heard some of this classic rock, again, the Beatles, the Who, the Stones, Crosby, Stills and Nash, Carly Simon, Simon and Garfunkel, no, it's different Simon, by the way. You owe it for yourself to listen to some of this stuff. It's really, really good. I think that I read someplace that when you hit a certain age, maybe 35 or so, you're not as open to new music. Although, again, some of the newer stuff I do appreciate. But I know a lot of younger people, the idea of listening, if you're born in 1990 or born in 2000, the idea of listening to something from the 60s or 70s, that's old people's music. It's really not. I mean, it's really, the rock and roll era, some really good stuff out there. So if you have not listened to it and you're, younger, or even if no matter what age you are, it's worth a listen. It's worth a listen. It's good stuff. Brian, should I stay in SSDI? I'm at 64. Should we 75 for says, I think if you're on SSDI, Brian, then stay on SSDI. I mean, you can look at the numbers to see how much you would get SSDI versus retirement, but generally speaking, it makes more sense to stay in SSDI because when you take SSA retirement, you're giving them a discount. So I would just look at the numbers. What will you get? What will your monthly benefit be? And when you go with what's higher, I would think. But it will transfer, as Elle says, it transfers automatically. Yeah, I don't think so. I don't think there's any advantage to applying for it at this point. Block's fruit picture. What is considered light work? Light work for Social Security, it's a term of art. It means standing and walking for 6 out of 8 hours in a day, lifting 10 pounds frequently, 20 pounds on occasion. That is light work for Social Security purposes. So jobs that require, or that less than that, or have obligations less than that, could be considered more sedentary type of work. Jobs that require more than that would be good at medium work. So, but many jobs, also the majority of jobs, are light jobs that you'll have to do that level of work, and realize that the way vocational witnesses testify that occasionally, once every week or two, you have to lift 25 pounds or 30 pounds. That's not going to take it out of light category. So it's generally what you do on for most of the time, but that's how they define it. Yeah, Shub says ERISA, which is for long-term disability. Most ERISA policies, which are company provided, your employer provided it to you, and you paid for it on your paycheck, that say that for the first 2 years, you're disabled under the long-term policy if you're unable to do your own occupation. You can't be a nurse, you can't be a teacher, you can't be a warehouse worker. After that, it's like Social Security, you have to prove you can't do anything. But again, every policy is different, and you got to look at them. And so, that's another reason why getting into Social Security makes sense, because the first couple of years, it's own occupation. Once you hit any occupation, that's when the long-term disability is going to look to cut you off. And if you've got Social Security, now you've proven to a federal agency that you can't do anything, a finding you can't do anything at all, and then you've got the backup there as well. Brian says a lot of people my age are applying for Social Security now because they're scared they'll be less money if they wait till 67. I don't, I don't have a crystal ball, Brian. I don't think that there's going to be a problem with Social Security paying its obligations for those people in their 60s now. And so when you hit 67, I don't think there's going to be a cut. If there is an across-the-board cut, it's going to affect everybody. But my guess would be that Congress will wait until the very last minute to make a change. They'll either increase taxes, they'll borrow money from some other department, and they'll make their obligation. The AARP is a very powerful lobby for retired people. They're going to have a conniption fit if there's any change to Social Security retirement. Not so much disability, but retirement. So I personally don't think it's going to be a problem for retirement. If you are 40 years old or 30 years old, yeah, I think those people are going to see a problem. They're going to see a change in their retirement. It may be means tested, meaning they may say if you have assets or income over a certain amount, you get less. It may be they change the retirement age. They've done that before. I think the people in their 30s and 40s are the one who are going to get the shaft, as it were. I don't think the people that are in their 60s now are going to have that happen to them. I will tell you that, if there's any discussion of doing something for people that are in their 60s, and it makes sense for people, 63, 64, 65 to retire early, you're going to see this mass movement of people retiring early, which will be a more drain on the system. So I'm thinking that they'll sort of cut it off at age 40 or 45 and say anybody, that was born after 1975, let's say, it's going to affect them. But if you're born before 75, then it's not going to affect you. That's my guess. I'm not telling you I have any inside knowledge. That's my guess. A web design 05. Thank you for your professional guidance advice. 47-year-old TOS, mental health prior suicide attempts, mild traumatic brain injury from car crash with lingering effects, autoimmune condition. Not sure what. Let's see what TOS is. Not sure what it means. Thoracic outlet syndrome, perhaps. I don't know if that's what you've got. That's what TOS is showing up on Dr. Google. So maybe so. It's can be a disabling condition. Again, I would tell you, Webb, 47 years old is the issue. If you're under 50, you've got to have, let's say that there's a cylinder full of liquid. You got to be right close to the top. You're 50, you're right at the middle. You're 55, you're sort of, a third way up. You just have a lot more medical evidence at 47. Not as much as you might have to have at 25, but a lot. At 47, they consider to be a younger individual. And they tend to lump people, 49 and 364 days and below into, younger individuals. So I think that's the big issue. You would have to prove you can't do anything at all. Literally a job where you're sitting at a table putting ink pens in a box. And, mild traumatic brain injury, is that going to really do it? Thoracic outlet syndrome, if that's what TOS you're talking about is, how severe is that? I mean, it's just an uphill battle. I'm just going to tell you, I've represented a number of clients recently with, I thought, really strong cases that were in their 47, 48, 49. Sometimes they get approved, but a lot of times they don't. Same case at 53, at 57, gets approved, no problem. So just my observation. Retire early and fall. Yeah, I mean, now early retirement, that is true. Now there are people who reach out to me and they've not done anything. They've just stopped working and they want to retire early to get their money coming in, and they apply for Social Security with the idea if they win Social Security, then the retirement benefit gets bumped up to full retirement at 66 or whatever. So that's a different story. But if you are already on disability, which is approximately what you get from full retirement, why would you claim retirement if it's going to be a lower amount? It just doesn't make any sense to me. But again, you can do, there are calculators online. There are people who do this, and they can figure out what you would get and just make a calculation based on what you're going to get the most money from, most benefit from. Okay, so AWeb is 47. They say it's not severe enough, can't work more than a few hours, to numbness in the leg and arm, migraines and back pain. And I'm not doubting what you're saying. I'm just telling you that at 47, it's going to be a lot harder, even if you've got these conditions which on their face are disabled. You can only work for a few hours a day. Is a judge going to believe that? And at 47, not as much as they would believe it if you were 55. I think blocks few. I think you're talking about the VA and Social Security. They don't talk correct. So you've been on SSDI since '89. You won't get more money because you have no work history. Again, I just would try to figure out what you're going to get if you can find out what you're going to get from early retirement versus SSDI, and is there any advantage to changing it over? There are people out there who are experts in what they call Social Security claiming. I'm not one of those. I don't deal with retirement issues, but that may be something to run by somebody like that. You could reach out to, what's his name? There's a gentleman who's got a YouTube channel. Oh, I mean, Greg might be of help to you. Let me see if I've got his name. Greg Brinkley is one person to talk to. Greg at gregbrinkley.org. Um, there's a gentleman named Ed Weir, Weir. His email address is ed@mygovexpert.com. ed@mygovexpert.com. He might be able to help you with claiming issues. Greg might be able to help you. Greg at gregbrinkley.org. There are other people you can reach out to that can give you help with this, some for a fee, some at no cost. And that's what I would do. It's probably worth investing a little time and maybe a little bit of money into getting some advice about claiming. DG, okay, let's go back to this one. Still undergoing physical therapy for second surgery, no guarantees. Again, my thought is that if you were 55, you got a strong case. At 47, you're going to have to hope you get a sympathetic judge. That's what I would tell you about it. DG says, DDS set me up for 2 CEs, then canceled the week from appointment, sends my case back to the local office, and I see an online denial claim. What's going to think they did it to me? Why they do it to you? The only thing I can tell you would be that the in-house medical provider basically said that there's no evidence at all this person meets a listing. The CE evaluations are not going to be comprehensive enough to make that call. I don't like to speculate on what adjudicators are doing. Again, somebody made a conclusion that there was never going to be enough evidence there to approve you early. So they just went ahead and denied you. That's really what's going on here. So you need to appeal, is what I would tell you. Let's see, we got it here. Brian Harris has had on. Brian's been on since he's at 89, I believe. Only had 2 CDRs in 35 years. So obviously your case was coded as one where medical improvement is not very likely. L. Brown says the cases I know that received their pension funds went for SSDI. Okay. Again, pension's not the same as retirement Social Security. So make sure that we're talking the same language here. Should you get an attorney during the reconsideration? I always tell people this. In fact, I had this conversation today with somebody who has been on here before and frequently asked questions. If you've already filed a reconsideration, the reality is only about 15-16% of cases that recons are filed for get approved. If you've already done it, there's probably not a whole lot more that an attorney can do. Now, if the case is unusually strong, what I do is I might write a memo to the adjudicator explaining why the case needs to be approved early. Sometimes that does work. Some people like to have me on because it means I'm getting copies of the notices, which, believe it or not, is a big deal because Social Security is not always the best about sending out notices timely. If you got 2 people who are getting it, and of course I have an electronic system that tells me when a case is denied, there's benefit there. Help in filling out the forms, some benefit there. But the reality is you need an attorney for a hearing. You don't absolutely have to have somebody at recon. There are some advantages there. That's a decision you've got to make. But I would never tell somebody if they've already filed a recon. If it was me, I would probably say the odds are not going to get approved. But let me hope I do, and if I do, I get 100% of the past due benefits. Look, I'd rather you get 100% of the past due benefits. The problem is if you get me involved in a case, or any attorney for that matter, we have to open a file. We've got to do our, get everything geared up. And, if we're filing something and we're assisting, then, we're providing a service that arguably is resulting in your approval. And so, people sometimes get upset. Well, why are you getting 25% of my back pay? Well, you got me involved. I told you that this is not, have to have me, but obviously I provided some sort of benefit to you. But that's a judgment call on your part. And if you feel like there's a reasonable chance of you getting approved and just want to wait it out, and maybe you get approved and you get 100% of the past due benefits, that's cool. more power to you. But do get an attorney for a hearing, I would say. Brian gives me a smiley face. Thank you, Brian. And speaking of smiley faces, let me ask people here to leave me a nice review. If you're getting benefit out of this live stream or the other videos I've gotten, I just recorded a bunch more. We'll be getting those out soon. And again, I'm going to have some guests coming up. We're going to have Lindsay Osterhout next week, and I'm going to have the week after. I'm going to have Adriana is going to be back, De La Torre, who's the appeals lawyer, and I've got some other people lined up as well. If you find this useful, give me a nice review. It really, really helps me. I would really appreciate that. Okay. Blocks fruit. Is it normal for legs to go numb when standing in? No, absolutely not. Absolutely not. That is a sign of something that could be a nerve issue. There could be some sort of a blockage in the nerve. They call it nerve root compression, claudication. There's any number of terms for it, but that says there's something going on with your back. I Chin says, I'm amazing. Well, I don't know. Some would say yes. Some would say no. I'll take it, but thank you very much. I'm an intelligent lawyer. Well, hopefully, after 30 years of it, I'd figure something out. Oh, thank you, though. Elle, thank you very much. Lunch on mute. Well, I'm not going to spend $20 on lunch, but actually my son, I was talking to him today, and he said he found a Greek restaurant not too far from here. He was like, it was really good. He had to buy something, and he was driving around, and so he said, this is a great Greek restaurant. So I actually got a sandwich today there's an Italian deli called East 48th Street, not too far from me, and it's kind of a small hole in the wall. They do a lot of catering, and they have a small, like outside little, maybe 5 or 6 tables, but they make the most delicious sandwiches. And so I get like a mozzarella and pesto sandwich or a tuna sandwich or sometimes a turkey sandwich. And, it's just really, really good to have those little small delis around. And, I'm not a big fan. You go to some of the, the corporate, I'm not going to mention names of some of these corporate, quote unquote, delis that aren't very good, or some of the chains that have, really high prices. But the small mom and pop, and this is literally a family-owned business, really, really good. I've been to, my wife's aunt and uncle and first cousins are up in New York, and there's a place we went kind of like this, but sort of on steroids. And I've been to some of these places. You find a good Italian deli, really, really good. So, Elle, thank you very much. And this will go towards, I'll take my son Jake. I'll probably treat him to lunch at some point the next few days. But thank you very much. I really appreciate it. Well, Hope, look, I try to share what I know. So thank you very much. And you're right. I think that you make a really good point, Elle, because when you are waiting your hearing or in the process, read your medical reports. This is, get a copy of your file. You should really know what's going on. You have to be your own advocate, so absolutely. Absolutely. Having medical cannabis card, I would say no. I have not seen that ever become an issue, certainly in the last 10 plus years. Technically, marijuana is a Schedule 1 drug, but if you've got a marijuana card by the state, I've never seen a judge have a problem with it. So there's a little bit of a conflict between state law and federal law, but I've never seen it be a problem, personally. Yeah, you could do that, move to a state with recreational cannabis, certainly. It was actually an article, Brian, in the Atlanta newspaper the other day where the majority of people in Georgia believe that marijuana needs to be legalized. I know that cannabis oil is, because I know people with irritable bowel will take that. I've got a friend, and she takes it for irritable bowel. I'm kind of a mixed opinion about that. I've never really been a user of marijuana, just not my thing. I'm not a drinker or anything like that. I don't have a problem with people who take it. I think that there are people out there with addictive personalities, and giving people with those personalities another substance that can, they can pursue. Not sure how healthy that is. On the other hand, alcohol is legal. And if you have that addictive personality, you're going to drink. Is there much of a difference? Probably really not. So I guess all in all, I'd probably come down to the side they should probably legalize it. Get the tax revenue about it, make sure it's safe. You hear these stories are just heartbreaking where people, young people are they buy marijuana and it's laced with fentanyl or some other foreign substance. So at least with the dispensaries, you are pretty much assured it's going to be of good quality. I think the day is coming, quite frankly. Probably not with this administration, but the day is coming where the federal government will legalize it and states will follow suit. Um, is it a net benefit to us as a society? Probably not. But on the other hand, is it going to make a really big difference to people who want to, you know, get high or whatever? Probably not going to change things that much. It may make it a little more acceptable for younger people. I mean, my feeling is when you tell somebody, especially a teenager, you can't do this, they're going to want to do it. And if it's legal, it's not going to be that big of a deal. I mean, like I'll give you an example. I grew up in a house. No, my parents did not smoke or drink. They would have like a glass of wine every once in a while. So we would have wine in my house. It was open right there. And I took a sip of it when I was young. It tastes, of course, when you're 9, 10 years old, wine tastes terrible. But it was never forbidden. But I had no interest in it because I didn't like it. So it was not like it was forbidden fruit. But when you're 17 or 18, and your parents and your teachers say you can't have that, then of course, what do you want? Exactly what you can't have. So, I guess, like I said, I would probably come down on saying that I agree with you, Brian. Deb is here. Deb says, stay on SSDI, you take a 20% lifetime reduction. And again, I think this is about the claiming strategy there. Wine is a good alternative. It depends, I mean, even now, I like, Merlot or certain red wines. If I never had a glass of wine again in my life, it wouldn't really bother me that much. A good, Merlot or Pinot with a nice meal, I'll enjoy it. But again, it's just not something that really moves my meter. I did go out to Oregon with some friends of ours who knew somebody who got us some tours at some wineries. And literally, if you've ever been to a winery tour, and this is in the Willamette Valley in Oregon, which is a really nice wine growing region, we would have these tours starting at 9 o'clock in the morning. And so you would taste the wine, then you'd spit it out because you don't want to be drinking wine. First of all, you had tours all day. So if you're drinking starting at 9 o'clock in the morning, you're going to be, smashed by the time it's 10:30, which is kind of early for drinking. But you'd spit it out and you just would go from one to the other and taste the different wines. Could I tell you the difference between a Willamette Valley Pinot and a California Pinot or a, European? Probably not. There are some wines I've had that I can say, oh, this is really good. This is a really, got a really nice taste to it. But again, I don't have that palate. I mean, I could tell you more about dark chocolate. That's probably I know more about that than, I'll try different. One thing I do, and I don't know why I'm telling you about this, but I'll tell you, there is a farmer's market called the Buford Highway Farmers Market, not too far from where I live. They have food from all over the world. I mean, they'll have, South American food and Japanese and Korean and everything. They have a whole section of like chocolates, Russian chocolate, Ukrainian chocolate, European, German, Polish, you name it. And so whenever I go, I'll pick up chocolate bars, and I like the dark chocolate, like the 72, 80% chocolate from all these different places. And at one point I was kind of keeping track of it all. Now I just kind of enjoy it. But I can tell you, the difference between a really good dark chocolate and one that's not so good, like like a Lidl special, for example, versus a Ghirardelli, or Trader Joe's organic versus Trader Joe's. I can tell you the difference because I just have that palate because I like it. But I couldn't tell you one wine from the other, beer from the other. I don't know. So I'm a chocolate guy. So if anyone else wants to send me dark chocolate, feel free. But wine, nah, not so much. Okay. Brian was told to wait till his full retirement. That's cool. All right, Josh Smith. Any advice for dealing with inaccurate information in medical records, SSDI and CDR, and a lot of inaccurate and complete false information in your records? I would write it all down. I would make a list of all the false information. And I wouldn't take it personally. I would just be very factual about what is wrong. And then, if you go to the CDR and they move to terminate you, whether you want to be proactive or not and put that inaccurate information to Social Security early on, that's kind of a strategy call. Or do you wait until they move to terminate you? That's just a judgment call. But I would certainly now go through and, you know, identify the errors. Now, realize that an error, you know, if they said you were 47 years old when you're 57, that is an error. If they said that the MRI shows no disc involvement and shows a herniated disc, that's an error. If the doctor makes a comment about, you know, something, his observation, the patient does not seem to be limping, or an opinion, that's not really necessarily going to be an error. And so, you know, whether you want to call attention to that or not, I don't know. You might want to talk to, if you have an attorney, talk to somebody about, is this really an error that I want to make a big deal about? Sometimes drawing attention to something negative in your file might be worse than just letting it be, if that makes any sense. Can you get off SSI for 9 months? I don't know that you can get off and then get back on. That's the problem, because if you work, they may conclude that you are no longer disabled. So it's not like you can sort of just, now you can go, the SSI, there's no trial work period for SSI. SSDI, there is trial work period. So if you're in SSI and you go to work, I think the risk is that, you know, you maybe find yourself off, especially if you've said, I'm going to work for 9 months. I'm going to suggest that you have the capacity, you're taking advantage of a short-term job opportunity, then you want to go back on disability. That almost sounds like it's a little contrived there. So I don't know that I would go that route. Okay, Michael Burris, an SSDI for 3 years, I drive Uber and occasionally scared about the benefits. I think the main thing, Michael, is the amount that you earn. Now realize with Uber, you're responsible for gas, vehicle maintenance. That comes off the top. I would, again, if you're within the 9-month trial work period, you can work for 9 months with very little risk, I think, because that's trial work period. And you may not reach trial work amount. I think it's $1,110.25. You look that up. But the point is that if you factor in and keep track of your expenses, you may not even reach trial work period, which I think is pretty safe. And then if you do use up your 9 trial work period months, then you have to stay below SGA. That's a little riskier because now there's ongoing earnings that will be reported to Social Security. So I think it's a kind of a strategic decision. Do you go to work as an Uber driver and see what happens? You know, I would probably tell you to test it for 4 or 5 months and see what happens. And if you have not used trial work period months, that's even better. But I think I would try it for a few months and just see, you know, is low-level earnings, let's say $500, $600, $700 a month ongoing? Are those earnings going to create a problem for you? Marginally, maybe, but is it worth having the extra money? Is it worth having something to do with your time? Worth that risk? Probably. I mean, I think it's just a judgment call. I mean, I just, you know, I know for myself, if I was on disability and I'm looking at staring at the walls for 8 hours a day, all day long, I would go crazy. I would want to find something to do. And again, Social Security, from their perspective, if somebody's on disability and they review and they cut everybody off who tries to work, what is going to be the word that gets out? Don't try to work. They don't want to do that. So they only want people who are really able to work. I think Uber is one of these things where, you know, I had a client was DoorDash the other day. Uber is one of these things you can choose to accept or not accept a ride. I mean, you know, you could, if you're not feeling good, you might do 3 or 4 rides and then say, I'm not feeling good. It's very much up to you. So it's not like taking a job where you're committing to a shift, right? And what you earn, you know, you can kind of control what you earn. I think if you keep it below, certainly trial work period level, you know, let's say make it below $1,000 a month, I think you're probably pretty safe. You get closer to SGA, which is 1,620 in 2025, a little riskier. So if that gives you any guidance. Nathan Dotson has a political opinion. Okay, I hear you. I think we just talked about this. Chen, if you work a part-time job, I think again this is just going to this is going to just be the question of strategy. How much do you want to work, and how much is it are you willing to take a risk? And so, Nathan, are you asking about this comment here or something else? I didn't see anything else. So, again, I'm not going to get political here because I think everybody's got their opinions. And I think that, there are people across the political spectrum. And again, this is not the platform to go into politics. I'm just trying to win cases for my clients. I think that there are people hostile to Social Security disability on both sides of the aisle. I will tell you that I've done this for a long time, Republican, Democrat. It doesn't really seem to make a whole heck of a lot of difference. I just think that, in Congress, there is a narrative that you have to realize the way Congress works. They want to get reelected. They want money. People on disability are not a lobby group. The AARP is, but people on disability are not. So really the big attitude I get about Congress for the most part is indifference. They don't care. They don't really care. People on disability are not going to give them any money. They're not going to be a committed voting bloc. Republican, Democrat, they don't care. All they care about is raising money and getting reelected. You're on disability, they don't care. Now, I will say that most Congress people, Republican and Democrat, they have people in their office that will do the congressional inquiries, and they want to help constituents who they see you as a vote. But are there some politicians committed to the disability program? Yeah, there are some. Most of them don't really care. I hate to tell you that, but that's just the reality of it. And I think this is just going back to what I was telling Michael Burris before, is it just depends on how much you earn. I think if you keep it below 1,000, you're cool. If you keep it below 1,620 for this year, you're probably okay. You go over that, you got a problem. Who is my question? I think, you can't make SGA is a set number, $1,620 in 2025. So if you stay below that and realize for things like Uber, you can take off the top the cost of vehicle maintenance and gasoline. I think if you have ongoing earnings, the way I look at it is, let's say you're working Uber or you're working someplace and you got ongoing earnings of $1,550 month after month after month, Social Security, they're going to see that, and that might trigger a review because they're saying you look like you're intentionally keeping it below that SGA threshold. If it's sort of bouncing around, 1,000 here, 1,200 here, 400 here, 900 here, less so. I don't think we can predict what somebody at Social Security is going to make a decision about, what they're going to do. Again, big picture, if you've not used up your trial work period months and you keep your earnings below trial work period, I think you're pretty safe. I'd say you're 80% safe. If you use up your trial work period months and you stay below SGA, you're still safe, but there's a little bit more risk. If you're used up your trial work period and you're really close to SGA month after month, that risk starts to go up. And how much the risk will change with the new commissioner and the Doge people, I can't tell you, but I just would tell you it's kind of a common sense kind of thing, just to be careful about it. But I think, again, for me, looking at the walls 8 hours a day would not be something I'd want to do. Charity, I've been 46. I haven't worked September of 2006. The problem there, Charity, is that if you had a hearing and you were denied, you didn't appeal it, your date last insured is 2011. You've already had your hearing in 2018, so it's been decided that you are not disabled before that date. So anything you apply on now is going to be SSI only. And if you've got a spouse or other assets or household income, you're going to be out of luck. So SSI is a hard road to go, especially if you've got a spouse or something like that. Thank you for all the helpful information. How long should I receive an adult function report? I'd say a couple of months, but you know what? Go look it up online, or go fill it out online. Have it ready. There's nothing that says you can't submit it ahead of time. So do it. get it to them early. No reason you can't be proactive with that. Okay, so Deb talks about the Ticket to Work program. I don't know anything about that. I've not heard really good things about it, but the trial work period. In fact, I'll tell you what I'm going to do. I'm doing a seminar about the trial work period, teaching other attorneys in a few weeks. And the materials, I had to do some research on it. I kind of really wrote a whole, presentation about the trial work period, things I didn't necessarily know about it. I'll put that on. I'm going to find a place to put that online. So I'll get that online next few weeks so I can give you the link to it so you can have, what I know about the trial work period, which is more than I used to know about how all that works. And I think that you may find that useful. So I'll get that out when I find a minute. Can you work for yourself when that's legally blind? Again, the earnings are going to be the big issue. Earnings. So if your earnings doesn't matter. Now, being legally blind, I will tell you the SGA amounts are different than they are for non-blind. So that's a whole different ballgame. I don't have time to go into that now, but look that up. The SGA for blind versus non-blind. And have you been deemed blind for Social Security purposes? Interesting question, Josh, and I'm going to close this out in a few minutes because I'm already at 2 hours. If you receive SSDI, I don't plan on applying, would it be a good idea to lock your SSN through E-Verify? Could prevent somebody I've never heard of that. I mean, I did E-Verify for my employees for a period of time. I don't need to because I don't have enough people, but I did it just because I thought it would just make sense to do it. I don't know. That's a very good question. I don't know the answer to that, whether there's any benefit to you to register with E-Verify or not. I always thought it was just to prove that you were legal to work. But I don't know that it locks anything in. Or as a credit bureau, I've not heard that, but I could be completely wrong. Okay, let's try to go. Let's see if I can get. Carly Simon about the Heinz ketchup commercial. That's right. Anticipation was her, because she's making you wait. Heinz ketchup, he pours out really slowly. That was what that was about. Okay. Let's see if I've got anything else here. Thank you very much, Shub. I appreciate that. Like I said, I'm going to ask people to. I've got the enjoyment. So let me put this one back here. All right. Let's got a time for a couple of more here. Comment from Brian about cannabis. I think that it can be valuable. I know people who find it very valuable. Dark chocolate. No, look, 70% chocolate. Supposedly it's good for you. Probably not when you eat like 5 squares of it, like I tend to do, but it's really good. I do like it. It's not so sweet. I don't like it. It's so sweet, but dark chocolate, like I said, for me, Ghirardelli is what I kind of as my go-to. The Lindt is okay. I think there was actually a couple of European Russian ones that were pretty good. Had a little different flavor to it, but yeah, good dark chocolate is just a nice way to cleanse the palate. It's really really good. A lot of people, like I said, what's interesting, and again, I'll leave. I don't go on this tangent. My wife's first cousin used to have a chocolate store, and he would make chocolate dip pretzels and chocolate dip potato chips and sell them as corporate gifts. And so, we went to the store. It's like, grab whatever you want if you want to have some. So I grabbed a couple of Hershey's Kisses because why are you wasting your time with that? It's all filler. Get the real stuff. The chocolate that's 72%. And he's like, if you know what you're looking for, it's really good chocolate. You can get a Ugandan chocolate or Mexican chocolate. It's really got a very, very complex flavor. I'll use a wine term. And it's really, really good. And although you have to be careful about some chocolate has cadmium in it, which is a carcinogen. So you got to be kind of careful about that. You can look up, which chocolates have that in there, but a little bit, it's not going to be a big deal. But chocolate's really, really good. Okay. Okay. So Josh talks about false information. Okay. I think that's a good point. The therapist canceled appointments, then said that you had made lack of engagement. Yeah, I think that would be something where you could say they canceled the appointments. It wasn't me. I was willing to cooperate. That would be a something to put on a report there. Okay, I'll make this the last one. Chalub. I'm at the payment center for international payment. It could be 180 days. I would reach out to your U.S. senator. That's outrageous. Outrageous. That's way too long. Okay. Okay. Well, great, Brian. Thank you for the kind words. And I would be professional dark chocolate. Well, you can come after me. I'm that's going to be my next job. That would be fun. Although, I bet if you were a professional dark chocolate taster, it would lose its luster because you'd be doing it all day long. So I don't know. Do psychiatrists get cancer? I'm sure they do. I'm sure they do. Okay. All right. What can I do to help my legs? I mean, I think that you got to find out why they're going numb and see if there's any kind of treatment. I mean, I know people take Neurontin or gabapentin for nerve pain, but maybe even this might be something to, physical therapist, even a chiropractor, just to try to get things going again. But give it maybe an MRI would be appropriate. I mean, I'm not a doctor, but I think you got to find out why. That's not normal. Definitely not normal. So, okay, let me end this now. We've been at 2 hours and 6 minutes, and it's time to go. So again, next week, Lindsay Osterhout, an old friend of mine. Again, husband's Carl, who's one of my go-tos for appeals. Lindsay does the same kind of thing I do. We've worked together for years. We'll share cases back and forth. We've done CEs together. Very sharp woman, and she's going to give us her insight about what happened at the NOSCR convention, what's going on, and of course, answer questions from everybody as well. So I will leave it here. Thank you very much for tuning in, and we will see you next week. Thank you very much.